You've heard the phrase assault and battery a million times, right? On TV, in movies, it always sounds like one big dramatic event. But, in the eyes of the law, they are two completely different things. And that confusion, even for lawyers, has created a real terminology minefield. So let's try and separate the TV drama from the legal reality. So let's just cut right to the chase. Are assault and battery the same thing? The short answer? Nope. Not at all. And understanding that difference is absolutely key to seeing how our justice system protects us from both the threat of harm and the harm itself. Okay, so here's the absolute core of it. Assault is the threat, while battery is the impact. The easiest way to think about it is this. Raising your fist to someone, making them think they're about to get hit, that's the assault. Actually landing the punch, well, that's the battery. One is all about creating the fear of being hurt, the other is the actual unlawful contact. All right, let's dig into that first piece of the puzzle, the threat. This is what the law calls a technical assault, and believe me, its definition is way more complex than you might think. So in legalese, the physical act of a crime is called the actus reus. For assault, that act is causing a victim to apprehend imminent force. Now, this is key. Apprehend here doesn't mean they have to be scared out of their wits. It just means they have to be aware of it, to expect it. You could be the toughest person on the planet, totally unafraid, but if you see a punch flying towards your face, you apprehend it. And legally, that's enough for an assault. And this just goes to show you, an assault doesn't require a raised fist or any physical gesture at all. In the famous case of R.V. Ireland, a series of silent phone calls was actually deemed an assault. That chilling silence, the heavy breathing on the line, it created an apprehension of imminent harm. As Lord Staines so perfectly put it, a thing said is also a thing done. Words, or the terrifying lack of them, can absolutely be a weapon. But, and this is where it gets kind of weird, just as words can create an assault, they can also cancel one out. Take this classic case from way back in 1669. A man puts his hand on his sword, a clear threat, but then says this. He was basically saying, I'm not going to hurt you right now because the judges are in town. And you know what? Those words completely negated the threat. They showed there was no imminent danger. And this whole idea of imminence or immediacy, man, it has been a total headache for the courts, especially with modern problems like stalking. The definition has had to stretch over time. So back in 1983, a man standing outside a window was seen as an immediate threat. Fast forward to 1998 with those silent phone calls, and the fear was about what might happen in the very next moment. By 2002, the courts had to broaden immediate even further to mean that violence is likely to happen soon. Okay, so that's the threat covered. Now let's talk about the impact, the real deal, battery. This is where things get physical. So here's the textbook definition. Battery is all about the application of unlawful force. This is the moment physical contact happens. And notice those words intentional or reckless. It doesn't have to be some premeditated attack. Just acting recklessly and causing harm can be enough to qualify. I mean, of course, we touch people all the time, right? Brushing past someone on a crowded train, tapping a shoulder to get someone's attention. The law gets that. For a touch to become a battery, it has to be considered hostile. Now, hostile doesn't necessarily mean angry or malicious. It just means it goes beyond the normal, everyday contact that we all accept as part of life. Okay, and this is where things get really, really interesting. You can actually commit a battery against someone without ever laying a single finger on them. The force can be indirect. Get a load of this case. A schoolboy pours acid into a hand dryer and then just walks away. Later, another student comes along, uses the dryer, and is horribly injured by the acid. The first boy never touched the victim, not once. But the court said his action was a direct, unlawful application of force. That is a textbook and pretty terrifying example of an indirect battery. The scope of what can be considered a battery is just incredibly wide. Spitting on someone? Yep, that's battery. Blocking an exit in a theater to cause a panic where people get hurt? Battery. Even an omission, like failing to do something, can be a battery. There was a case where a suspect didn't tell a police officer about a needle in his pocket before being searched, and the officer got pricked. That was ruled a battery. Okay, so that's all the legal theory. Kind of geeky, I know. But why does this distinction between assault and battery actually matter in the real world? Like, what's the point of the system being set up this way? Well, in practice, these offenses are usually handled at the lowest level of the court system, what's called the magistrate's court. They're typically used for cases with pretty minor injuries. We're talking grazes, bruises, maybe some reddening of the skin. They are not for the most serious kinds of violence. And the maximum penalty really reflects that. 6 months in prison. That puts these offenses firmly at the lower end of the criminal justice scale. So you might be asking, why so low? Well, it all comes down to a pragmatic choice by the justice system. The thinking is that sometimes going for a lesser charge can actually lead to a better, more just result for everyone involved. And here is the crucial human reason why this matters so much. Handling these cases this way is way faster and cheaper for the system. But most importantly, it can be far, far less traumatic for victims. Imagine forcing someone who's already been through a lot to endure a long, complex trial on a higher court for a relatively minor injury. It can be a terrible ordeal, especially in really sensitive domestic abuse situations. This approach tries to get justice done without adding to the victim's suffering. Now, I don't want to paint a picture that this is all perfect, because honestly, this area of law is messy. It's far from perfect, and it's constantly having to evolve to try and adapt old principles to very new problems. You know, the law is facing some huge hurdles here. The terminology is just plain confusing for most people. That immediacy requirement feels way too strict for an age of online threats and stalking. There's a big overlap with harassment laws, which makes things complicated. The Law Commission actually proposed a whole set of major reforms way back in 2015 to fix these exact issues, but so far, nothing has happened. At the end of the day, here's the core problem. We're stuck trying to apply principles from Victorian-era laws to 21st century problems like cyberstalking. And yeah, while newer laws like the Protection from Harassment Act have tried to plug some of the gaps, the core law of assault and battery is still very much playing catch-up. So, after all that, what are the big takeaways? Well, first, that words, and even silence, can be just as powerful and as unlawful as physical actions. Second, that the law has to constantly adapt to protect our fundamental right to be free from harm and from the fear of it. And finally, that context is everything. A tap on the shoulder is fine, but that exact same touch in a different context can be a crime. And it all leaves us with one final big question. As our world becomes more digital and threats become less direct, can a legal framework that was built in the 19th century really deliver the justice we need in the 21st? That's something for all of us to think about.